I get the same phone call every week. A wife, a mother, a brother, their family member was arrested in North Texas and is sitting in the county jail with an ICE hold. They want to know whether posting bond will get their loved one home. Sometimes that could be the right move, and sometimes it's the worst thing you can do, because the moment you post bond, ICE is there in the jail waiting. I'm Michael Lowe, criminal defense attorney in Dallas, over 28 years of experience, former Dallas felony prosecutor. Today, I'm explaining something that most lawyers are not going to tell you about with ICE holds. An ICE hold is a request from Immigration and Customs Enforcement to the county jail asking them to hold your family member even after they would normally be released. Dallas County, Tarrant County, Collin County, Denton County, every jail in Texas. It's not a criminal charge, it's not an arrest warrant, and no judge signed off on it. ICE filled out a form and just sent it to the jail. But if your family member posts bond, the jail does not release them to you. The jail calls ICE. The ICE has 48 business hours to pick them up, and they almost always show up. I call this the bond trap. Your family member gets arrested, the bondsman calls, the family posts bond thinking they're helping, but ICE shows up. Your family member goes from county custody into federal immigration detention. They get transferred to facilities in Louisiana, Georgia, West Texas, anywhere. You lose contact and access. The criminal case is still pending, but now almost impossible to fight. You just paid thousands of dollars to hand your family member to ICE. If your family member does not post bond and stays in county jail on the criminal charge, ICE can't take them. The detainer only activates when the person would otherwise be released. As long as the case is pending and bond has not been posted, they stay in county custody. I have access to the courts, and I can fight aggressively. The criminal case is the battlefield. Win it, and you change the entire immigration equation. A dismissal means no conviction for ICE to use in a removal proceeding. But that cannot happen if ICE already has your family member in a federal detention facility 500 miles away. Here's why this works. When the defendant has an ICE hold, prosecutors don't take their cases seriously. They expect the defendant to bond out, ICE picks them up, and the case just resolves itself through deportation. So they get lazy. They do not file cases quickly. They do not turn over discovery, and they don't even review their own evidence. But when the defendant stays in county custody, that cycle breaks. Now the state must deal with the case, and because they were not taking it seriously, that's when they make mistakes. I had a client arrested for misdemeanor DWI with an ICE hold. His family wanted to post bond, and I told them not yet. He decided to stay in the county jail. The state did not file the formal charging instrument for months, even though I was pushing them to do it. During that delay, a blood test came back to the DA showing that my client's BAC was a .06. The legal limit's a .08. He was under the legal limit. The state had those results. The prosecutor knew about them, or should have known, but because they expected the case to resolve itself through deportation or plea bargain, the exculpatory evidence sat undisclosed in their file. No right to discovery because the case wasn't filed. The prosecutor offered 3 separate plea deals while that blood test sat hidden in their file. 3 offers to plead guilty on a case where the evidence showed my client was under the legal limit. He refused every one. After months in jail and a speedy trial motion, I forced the state to turn over discovery, and I found out about the .06 result and the negative drug screen that they had been withholding. I filed a motion to suppress based on the Brady violation, the Article 3914H violations under the Michael Morton Act, and a denial of due process rights. The subpoenas flew. The next day, the state filed their motion to dismiss in the interest of justice. No hearing needed. The case was dismissed. My client had spent 180 days in county jail, the full maximum punishment for a Class B misdemeanor, without ever being convicted of anything. He sat in that jail because posting bond would have meant deportation. And by staying in county custody, he gave me the time and the legal tools to expose prosecutorial misconduct that would have stayed hidden forever had he bonded out. That dismissal fundamentally changed his immigration posture. No conviction, no plea, no ammunition for ICE to use in a removal proceeding. Not every case requires 180 days. Every case is different, but staying in county custody gives me the ability to fight. And sometimes that fight uncovers things nobody expected. If your family member is in a North Texas County jail with an ICE hold, do not make any decisions until you talk to a criminal defense attorney who understands immigration consequences, not an immigration lawyer, a criminal defense attorney. The criminal case is where the case is won or lost. I'm Michael Lowe, 214-526-1900. Everything I discussed, including the actual court filings, is at dallasjustice.com, link in the description below.